The rows run north to south. That's the first thing you notice, if you know where to look. Pull up the satellite image. You can see them. Long, straight furrows pressed into the earth, running from the tree line down toward the river. Then pull up the survey map from 1858, the Partridge Plantation. Later, the Angola Plantation. The rows run the same direction, the same spacing, the same dark soil, the same flat horizon, the same bend in the Mississippi just to the west where it curls like a question mark around 18,000 acres of the most fertile land in Louisiana. The crops changed. Cotton gave way to soybeans, corn, wheat. The workers changed their names. From enslaved to convicted. From property to inmate. The rows did not change. This is Louisiana State Penitentiary, Angola. The largest maximum security prison in the United States. It sits on the bones of at least 4 antebellum plantations, and it has been continuously worked by predominantly black men for 150 years. The average sentence served here is over 90 years. Roughly 75% of the people inside will die inside. They earn, and on the days when they earn anything at all, somewhere between 2 cents and 40 cents per hour for their labor. This is not a metaphor. This is acreage and pay stubs and the text of the 13th Amendment. You clicked on this video because of the title. And I want to be straight with you right now, in the first minute, about what I am going to argue. I am not going to argue that Angola resembles a plantation. I am going to show you that Angola is a plantation, structurally, legally, geographically, and historically. And that this did not happen by accident. It happened through a series of choices made by specific people, ratified by specific laws, and sustained by a specific silence that we have all been participating in, whether we knew it or not. I spent 4 months inside archives for this one. Parish records, convict lease contracts, court transcripts from the 1870s, editions of the Angolite going back decades, a deposition from 1951 that I had to order through an interlibrary loan from a library in Baton Rouge that no longer exists. I am going to tell you what I found. But first, stand in that field with me for a moment. It is June. It is West Feliciana Parish, Louisiana, which means the air sits on your skin like a wet cloth you can't take off. The temperature at 7 a.m. is already 83 degrees. By noon, it will be 97, and the humidity will make it feel like 108. The ground under your feet is soft and dark. Black clay that sticks to the soles of your boots and smells faintly of iron and rot and something alive just underneath the surface. Mosquitoes find the back of your neck. You can hear the tractor before you see it, a slow diesel groan coming from somewhere past the soy rows. And ahead of you, across the flat expanse, men are working. Long rows, long shadows, early light. They are wearing white. In Louisiana State Penitentiary, the inmates wear white. There is no official explanation that fully satisfies. White is visible. White shows dirt. White, in the brutal sun of a Louisiana field, absorbs heat the way a magnifying glass focuses light. The men wear white, and they work the rows, and the guards, some of them on horseback, watch from a distance. I want you to hold that image. We're going to come back to it. To understand how Angola became what it is, you have to understand what it was. And to understand what it was, you have to go back past the prison, past the Civil War, past the Confederacy, back to the land itself. The acreage that is now Louisiana State Penitentiary was assembled across several decades in the early 19th century by a succession of planters who understood that the bend in the Mississippi at this particular latitude created something rare. Bottomland so rich, so naturally irrigated, so sheltered from the worst of the river's fury, that it could produce cotton at a yield that made men extraordinarily wealthy. The land was called Angola. Named, most historians agree, after the West African nation from which a significant portion of the enslaved population in this region had been forcibly transported. The enslaved people who worked Angola Plantation in 1860 were, in many cases, descendants of people taken from the very place the land was named for. This is the first layer of the burial. The primary planter who consolidated the Angola acreage in the antebellum period was Isaac Franklin, who by the 1840s had become one of the wealthiest men in the South through a business that is worth naming plainly. He was a slave trader. Franklin and his partner John Armfield ran the largest domestic slave trading operation in the United States, moving enslaved people by the thousands from the Upper South to the cotton frontier of the Deep South. Franklin used the profits from that trade to buy land. He bought Angola. He died in 1846 and left his estate, including the land and the people working it, to his wife. The plantation continued to operate under subsequent owners through the Civil War. By 1860, the Angola Plantation and the neighboring Laurel Hill and Morganza properties held over 3,000 acres under active cultivation. The enslaved workforce numbered in the hundreds. They lived in quarters along the river road, wooden structures that let in the winter cold and held the summer heat, set at a distance from the main house that was precisely calibrated to be close enough for utility and far enough for the comfort of the people in the main house. The cotton grew. The workers picked it. 12-hour days in summer, 14 in the harvest weeks, hands bleeding by October from the sharp edges of the open bowls, the particular pain that is both sharp and dull at the same time, the kind of pain that becomes the background texture of life when you encounter it every day for years. The cotton moved downriver. The money moved to New Orleans, to London, to the counting houses of men who never once set foot in the field, but whose signatures appear on the ledgers. Then Appomattox. Lee signed on April 9, 1865. The 13th Amendment was ratified on December 6, 1865. And within 18 months, the state of Louisiana had engineered a legal mechanism to put black men back in the fields. This is the part that moves fast in the history books. And I need you to slow down with me here, because the speed of what happened is the point. The ink on the 13th Amendment was still fresh when the Louisiana legislature began passing what historians call the Black Codes, a series of statutes that criminalized vagrancy, criminalized unemployment, criminalized the failure to carry proof of a labor contract. A black man in Louisiana in 1866 who could not produce a document proving he was employed by a white man could be arrested, convicted, and leased, like equipment, like a mule or a cotton gin. The convict lease system in Louisiana formally began in 1869, but its machinery was already grinding 2 years before that. And the man who would become its most important operator in the post-Reconstruction era was a former Confederate officer named Samuel Lawrence James. James was born in 1835 in Mississippi. He served in the Confederate Army, as a major, some records say, though the rank varies depending on the source. What is consistent across every record is what he did after the war. He returned to Louisiana. He watched the legislature pass its new criminal codes, and he made a calculation. He approached the state government with a proposition. Give me the convicts. I will feed them, clothe them, house them. I will take them off the state's hands entirely. And in exchange, I will pay you a fee for each one. The state of Louisiana agreed. The first formal lease James secured was in 1870. Within 2 years, he controlled the labor of every state prisoner in Louisiana. The fee he paid the state was $5 per convict per month, $5 per man per month. He was releasing their labor to planters and railroad contractors and levee builders at a profit that made him one of the wealthiest men in the state within a decade. At its peak, the James operation leased over 1,000 men. The mortality rate among leased convicts in Louisiana in the 1880s was, in some years, over 20%. Men died of heat, of beatings, of infected wounds, of diseases that spread through the work camps because there was no incentive, none, financial or otherwise, for James or his sublessees to spend money keeping workers alive when more workers could be arrested and provided by the state. The camps themselves were not buildings in any meaningful sense. They were movable, tents and rough timber structures relocated to wherever the current contract needed labor. Railroad bed needed laying between Baton Rouge and Shreveport? The camp went there. A levee needed raising along the Atchafalaya? The camp went there. The men slept on wooden platforms in the tents, often shackled at the ankle through the night. They wore striped clothing. They were fed whatever the camp cook could produce from the budget allocated, which was not much. A man sick enough that he could not work was not generating revenue, and the sublessees were not in the business of carrying non-productive assets. The sick went to a corner of the tent and either recovered or did not. The ones who did not were entered into the ledger as losses, and the state was notified to provide replacements. I want you to picture the paperwork for a moment, not the suffering, the paperwork. There are actual ledger books from this period in the Louisiana State Archives. I have held photocopies. Column A, name. Column B, offense. Column C, sentence. Column D, condition at beginning of lease term. Column E, condition at end of lease term. Some of the entries in column E say deceased. The handwriting is neat. The ink is faded to brown. The columns are straight. Someone sat at a desk and entered those words. Deceased, deceased, deceased. In a neat hand, and then moved to the next line, and the next, and the book has 36 pages. I want to be precise here, because precision matters. In 1882, a New Orleans newspaper correspondent named George Washington Cable published a report on the Louisiana convict lease system. Cable was not an abolitionist firebrand. He was a cautious, establishment journalist who was genuinely disturbed by what he found. He wrote, and I am paraphrasing carefully here, that the condition of the leased convicts in Louisiana was, in several measurable respects, materially worse than the condition of enslaved people before the war. Not morally equivalent, materially worse. Because enslaved people represented capital. They had a purchase price that created a financial incentive, however brutal and degrading, for the owner to maintain them. Leased convicts had no such protection. When a leased convict died, the state simply sent another one. Cable published his findings. They ran in a national magazine. The response from the Louisiana political establishment was essentially, "Thank you, noted, and nothing changed." The state legislature convened a committee. Samuel James testified before the committee. Calm, well-dressed, a man of evident standing in the community, carrying with him the particular authority of someone who has made money doing something and therefore believes himself to have proven it worthwhile. He explained the efficiencies of his operation. He noted the roads and levees that would not exist without his labor supply. He pointed out that the state's penal expenses were essentially zero. The committee heard all of this, debated, issued a report. Nothing changed. There is a document in the Louisiana State Archives from 1887, a subcontract between Samuel James and a levee-building operation in Concordia Parish. It is 2 pages long. It specifies the number of men to be provided, 43, and the daily rate, $1.10 per man. And it includes a clause specifying that the contractor shall not be responsible for loss of contracted labor due to natural causes or the ordinary hazards of labor. Natural causes, ordinary hazards. The language does work. It takes the deaths of men and wraps them in the passive voice until they become operational footnotes. The lease ran until James died in 1894. His estate filed the final accounting. He had been enormously profitable for most of his 24 years in the business. His obituary in the New Orleans Times-Picayune described him as a prominent businessman and civic figure. It mentioned his contributions to state infrastructure. It did not mention the 36-page ledger. The Angola Plantation, by then heavily in debt, its soil worked hard by enslaved labor and then by leased convict labor for 30 years, was purchased by the state of Louisiana in 1901. The purchase price was $100,000. The state converted it into a prison farm. They kept the name. Let that land tell you something about the people who chose to keep that name. There were options. There are always options when it comes to names. Someone decided, and it was a decision, not an inevitability, that the prison built on land named after the country that supplied the enslaved people who made that land valuable should keep the name Angola. There is no memo that survives explaining this choice. There doesn't need to be. The choice is the document. The prison farm operated from 1901 under conditions that the reform advocates of the early 20th century described, consistently, as the worst in the country. Angola was not the only brutal prison farm in the South. Parchman Farm in Mississippi, Cummins Unit in Arkansas, the Walls Unit in Texas. But it had a particular ferocity that came partly from its isolation. 18,000 acres, surrounded on 3 sides by the Mississippi River. The 4th side is the Tunica Hills, dense and unnavigable. Angola was its own world. It set its own rules. The rules, for the first 60 years of the 20th century, included corporal punishment administered with a leather strap called the bat. The isolation box, a wooden cell too narrow to lie down in, forced labor in fields in temperatures that regularly exceeded 100 degrees, and a culture of guard violence that was occasionally reported in newspapers, occasionally investigated by state commissions, and never, in any lasting way, interrupted. Journalists who managed to get inside Angola in the 1940s and 1950s came out with reports that caused brief public horror and then subsided. In 1951, 37 inmates at Angola cut the tendons in their own heels with razor blades. A calculated, desperate act of self-mutilation designed to make themselves unable to work, to force a public reckoning. The story broke nationally. A governor's investigation followed. The investigation found real abuses. The investigation's findings were filed. New procedures were announced. By 1953, the strap was back in use. The men who ran Angola during this period were not anomalies. They were not bad apples. They were the product of a system that paid guards poorly, recruited locally, offered almost no oversight, and had been built on the foundational premise, never quite stated but structurally embedded, that the people inside Angola had forfeited their humanity at the moment of conviction. The guards carried that premise with them into every interaction, every decision, every swing of a strap. Many of them had grown up in West Feliciana Parish, the children or grandchildren of men who had worked the land when it was still a private plantation, when the arrangements of white authority over black labor were simply the natural order of things. Angola didn't ask them to question that order. It asked them to maintain it. The prisoners built levees. They picked cotton. They harvested sugarcane. They did the work that kept the farm running, and the farm's productivity helped justify the farm's existence, and the farm's existence helped justify the sentences, and the sentences fed the labor supply, and the labor supply fed the farm. This is what a self-sustaining system looks like from the inside. A federal court ruling in 1975, Williams versus Edwards, found that conditions at Angola constituted cruel and unusual punishment in violation of the Eighth Amendment. The ruling was significant. It forced real changes to the physical infrastructure, to the formal policies on corporal punishment, to the most egregious documented abuses. It is an important data point in any fair accounting of Angola's history. The federal courts intervened in a way that the Louisiana state government had not intervened in 75 years of self-governance. What the ruling did not change: the labor, the fields, the pay, the sentence lengths, the population demographics, the structure. You could smell the Angola fields from the levee road on a harvest morning, the thick green smell of cut soy and fresh-turned earth, and underneath it, if the wind was right, the particular smell of men who had been working in that heat since first light, a smell that is sweat and dirt and something older that doesn't have a word in English, something that anyone who has spent time around institutional labor in the South knows without being able to name it. Now I want to tell you about a man named Wilbert Rideau. Rideau was born in Lawtell, Louisiana in 1942. He grew up poor, educated in a segregated school system that gave him an irregular education, strong in some things, absent in others, shaped entirely by what was permitted to reach black children in 1950s Louisiana. In 1961, when Rideau was 19 years old, he walked into a bank in Lake Charles during a robbery, took 3 employees hostage, drove them to the edge of a bayou, and stabbed and shot them. 1 woman died. 2 survived. He was caught the same day. He was convicted in a trial that lasted less than a day and a half. The jury, all white because this was Louisiana in 1961, and the jury selection process excluded black jurors as a matter of course, sentenced him to death. He was 20 years old. He went to death row at Angola. The death sentence was overturned in 1972 when the Supreme Court's Furman v. Georgia ruling temporarily halted capital punishment nationwide. Rideau was sentenced to life. He stayed at Angola. Here is what he did with the time. He read. He read everything the Angola Library had, and when he had read that, he filed requests for additional materials. He taught himself law. He taught himself journalism. Not by attending a class, because that option was not available to him, but by writing, reading what he wrote, understanding what was wrong with it, and writing again. In 1975, he became the editor of the Angolite, the prison's inmate-run newspaper. The Angolite had existed before Rideau, but it had been a newsletter, announcements, sports results, notices about religious services. What Rideau saw in it, and what he turned it into, was something that required a particular kind of audacity to attempt inside a maximum security prison in Louisiana. He wanted to report, not institutional PR, not what the administration approved, what was actually happening. The first major investigation the Angolite published under Rideau's editorship was on sexual violence inside Angola. This was 1975, 1976. The subject was not discussed in public. It was not covered in newspapers. The official position of the Louisiana Department of Corrections was, implicitly, that whatever happened between inmates in the dormitories and cells of Angola was not the institution's concern. Rideau made it the institution's concern. He interviewed inmates. He documented specific cases. He named the structural conditions: dormitory housing, the failure to separate vulnerable populations, the guard culture that looked away, that made the violence systematic rather than incidental. He published it. The administration read it. There was a meeting. There was a conversation about what the boundaries of the Angolite's reporting should be. And here is the thing that surprises people when they first hear it. Warden Ross Maggio, who ran Angola in the late 1970s, and who was by reputation a hard man not known for progressive instincts, did not shut the paper down. He did not have Rideau transferred to a more restrictive unit. He allowed the reporting to continue. The reasons for this decision are not fully documented, but journalists and scholars who have studied the period suggest that Maggio understood, or was persuaded, that a paper with genuine credibility served the institution's interest in ways that a controlled newsletter did not. Real journalism produced real attention, and real attention, paradoxically, gave the administration a kind of accountability cover that pure suppression never could. Whatever the reason, the Angolite kept publishing. The Angolite, under Rideau's editorship, became something that should not have been possible in a maximum security prison in Louisiana in the 1970s. It became real journalism. Rideau and his co-editor, Billy Sinclair, reported on the conditions at Angola with specificity and sourcing, on violence, on sexual assault within the prison, on the economics of the inmate labor system, on the failures of the parole board, on the indifference of the Louisiana legislature. They named names. They cited documents. They ran the kind of investigative work that most journalists with full press credentials and institutional backing never attempted. Picture him writing. It is 1978, 1983, 1991. The year doesn't quite matter, because the image is the same. A cell in the main prison building. A metal desk. A manual typewriter. The keys require real pressure, and after an hour of sustained typing, your fingertips carry a faint, mechanical soreness. The paper moves through the platen, with a sound like a soft tearing. Rideau writes slowly in his early years, drafting by hand first, and then transcribing, because he has learned that the ideas arrive faster than his typing, and he needs to get them down before they change shape. His left eye has a slight droop, an old injury, he has mentioned it in interviews, and when he concentrates it becomes more pronounced, the lid settling low while the eye stays fixed on the page. He reads back what he has written. He crosses out. He writes again. Outside the cell door, Angola continues to be Angola. The stories moved through the walls. Reporters on the outside began reading The Angolite to understand what was happening inside Angola. Legal organizations referenced its reporting in briefs. Rideau was interviewed through the glass by documentary filmmakers. His essays, precise, unsentimental, built like arguments, were reprinted in newspapers that reached people who had never thought about Angola. In 1979, the Angolite won the American Bar Association's Silver Gavel Award. In 1980, it won a National Magazine Award. In 1994, Wilbert Rideau, incarcerated, still serving life at Angola, won the George Polk Award for Career Achievement in Journalism. The George Polk Award. Named for a CBS correspondent murdered in 1948, an award that has gone to Seymour Hersh, to Catherine Boo, to journalists who changed what the public knew about the world, and it went to a man in a white uniform in West Feliciana Parish, Louisiana, who was writing on a typewriter in a cell and had to request permission to make phone calls. I want to stay with what this means, because it would be easy to make Rideau's story simply triumphant, and that would be dishonest. In 1979, the same year the Angolite won its first national award, Rideau submitted a formal application for pardon to the Louisiana Board of Pardons. It was denied. He submitted again in 1986. Denied. In 1993. Denied. 3 more times across the 1990s. The Louisiana Board of Pardons denied Wilbert Rideau's application for release 6 times between 1979 and 2000. The man who had become one of the most respected journalists in the country, from inside a prison cell, was told 6 times by the state of Louisiana that he would stay. The victim's family supported his release. His prosecutors, by his final hearings, supported his release. Several former Angola wardens supported his release. The Louisiana Board of Pardons denied him anyway. I want you to feel the weight of that specific fact, not the abstraction of it. The specific mechanical fact of a man winning a George Polk Award in 1994, and the state of Louisiana reading that and responding, noted and no. In 2000, the U.S. Supreme Court ruled in Apprendi v. New Jersey that jury selection procedures that had systematically excluded black jurors violated constitutional guarantees. Rideau's attorneys filed a motion for a new trial, citing the all-white jury that had convicted him in 1961. After years of legal proceedings, he received a new trial in 2005. The new jury, selected under fair procedures reflecting the actual demographics of Calcasieu Parish, convicted him of manslaughter, not murder. He was sentenced to time already served. He walked out of Angola in January 2005. He had been inside for 44 years. 44 years. There is a man named Norris Henderson who understands what 44 years inside Angola means from the other direction. From the direction of innocence. Henderson was convicted in 1978 for a murder he did not commit. He was sentenced to life at Angola. He was 23 years old. He spent the next 27 years doing what innocent people do when they are trapped in a system not designed to care about their innocence. He filed motions. He studied law. He organized other inmates. He built relationships with outside advocates. He waited. He cultivated patience the way you cultivate a garden you're not sure will ever come to fruit. There is a particular quality to the patience of innocent men in prison that the guilty do not have. The guilty, at some level, have a framework. However unjust the sentence, however disproportionate the punishment, there is a narrative that can be constructed around guilt and its consequences. The innocent have no such framework. They exist in a permanent state of cognitive dissonance, holding at the same time the knowledge of what they did not do and the brute daily reality of where they are. Norris Henderson held that dissonance for 27 years. At some point, he has described this in interviews, though the exact year varies, Henderson was in the Angola Law Library. This is a room. Let me tell you what it looks like, because the physical space matters. Fluorescent lights, a low ceiling, metal shelves holding case reporters from the 1960s through the 1990s, a few computer terminals introduced sometime in the late 1990s, the smell of old paper, and the particular institutional smell of a room that has been cleaned with the same industrial cleaner every week for decades. Men sit at long tables. Some of them have been in this room for years. Some of them know the case reporters well enough to cite page numbers from memory. Henderson looked up from his work at the table. The men around him were bent over their papers. The fluorescent light buzzed at a frequency you stop hearing after the first month. And then one day you notice it again, and you realize you stopped noticing it. And that realization has its own quality, its own small grief. He looked at his hands on the table. He has said, "I knew at that moment that if I let myself believe the system was going to fix this, I was going to break. So I stopped believing the system was going to fix it. I started believing I was going to fix it. And that was the only thing that kept me." His conviction was vacated in 2003 based on newly surfaced evidence that had been withheld from the defense at trial, a prosecutorial suppression of exculpatory material, a violation of Brady v. Maryland that had been sitting in a file for a quarter century. He was released after 27 years. He did not disappear. He founded Voice of the Experienced, known as VOTE, a New Orleans-based organization run by and for formerly incarcerated people that has become one of the most effective criminal justice reform organizations in Louisiana. He has testified before the Louisiana legislature. He has sat across from governors. He has done this with a specific quiet force that comes from the particular authority of a man who has nothing left to prove to anyone. In an interview in 2018, Henderson was asked about the men who were still inside, the ones whose cases were not going to be vacated, who were serving life sentences that were going to run the full distance. He paused. Then he said, "Angola didn't break me, but I watched it break a lot of people. And the ones it broke weren't the weak ones. It broke the ones who kept believing the system was going to fix itself." The interviewer asked, What do you say to them? The ones still in there? Henderson said, I say, you are not what they decided you are. But also, don't wait on them to decide different. I don't know how to say that more clearly than he said it. Now I need to talk about Burl Cain. Cain became the warden of Angola in 1995. He served until 2016. He is, by almost any accounting, the most significant figure in Angola's recent history, which makes him also one of the most complicated figures in any honest telling of this story. Cain was evangelical, openly, emphatically, institutionally evangelical. And he brought that evangelicalism to Angola in a way that was, depending on your perspective, either the most genuinely humanizing thing to happen at the prison in decades, or a sophisticated management tool that made the institution easier to run while changing nothing essential about its structure. Under Cain, Angola saw real changes. The rate of inmate-on-inmate violence dropped substantially. A hospice program was created, staffed by inmates, that became nationally recognized. It was one of the first prison hospices in the country, and it allowed men who were going to die at Angola to die with some degree of human care and dignity. A college program was established. The physical conditions of the facility improved. Several wardens and corrections officials from other states came to Angola specifically to study what Cain had done. Journalists who spent time at Angola during the Cain years consistently reported something unexpected, that the prison felt by some measures less oppressive than it had been. Men spoke about the hospice work with something that sounded like genuine purpose. The rodeo, Angola's annual prison rodeo, which is its own profound and complicated story, drew thousands of outside visitors and gave inmates a connection to the outside world that had not previously existed. Burl Cain was photographed hugging inmates. There are images of him praying with men in their cells. He spoke about redemption in language that was plainly sincere, in the sense that he seemed to genuinely believe what he was saying. Several men who served time under Cain have described him as the first authority figure at Angola who treated them as fully human. And the inmate labor system under Cain ran with the same structure it had run under every warden before him. The men worked the fields. The pay is 4 cents per hour on the low end, 40 cents on the high. The cotton came in, the soybeans came in, the wheat came in. The prison farm generated revenue, and that revenue helped justify Angola's budget to the Louisiana legislature. And the legislature's appetite for that budget line was part of why the inmate population stayed where it was, why sentence lengths stayed where they were, why a man convicted of a nonviolent offense at 22 could find himself 40 years later still working the same rows. In 2015, the year before Cain retired, an investigation by the Marshall Project documented that Angola inmates were being disciplined for refusing to work. The mechanism: inmates who refused field work, for any reason including physical injury, could be sent to solitary confinement in a unit called the dungeon. This was not a Cain innovation. It predated him by decades. But it persisted under him. A man could be placed in a cell the size of a bathroom for refusing to pick cotton. I'm going to let that fact be the last thing I say about Burl Cain. I think he believed in his work. I think his hospice program gave dying men something real. I think the violence numbers are real. And I think the dungeon was real. And the 4 cents was real. And the rows were real. And he ran them all simultaneously without apparent contradiction. Which tells you something about what Angola is capable of asking of the people who run it. The system does not require villains. That is the sentence I keep writing and then deleting because it sounds like an excuse for individual men who made individual choices. But I keep writing it back because it is true and because it is the thing the history keeps proving. Samuel James was a villain, if you want a villain. A man who looked at the newly emancipated black population of Louisiana and saw a labor supply, and moved to capture it with legal instruments. Burl Cain was something more complicated. The unnamed guards who beat men in the 1930s were something else. What they share is a system that made their actions not just possible, but logical. When a system is designed well enough, it turns ordinary decisions into atrocities without anyone having to decide to commit an atrocity. The atrocity emerges from the architecture. The architecture I want to talk about now was written down. Signed. Ratified. December 6, 1865. Section 1 of the 13th Amendment to the United States Constitution reads, "Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Neither slavery nor involuntary servitude, except as a punishment for crime." Read it again. Slowly, because this is not a legal theory. This is not a critical race studies framework or an academic argument. This is the text. Primary source. The document that abolished slavery contains, in its first section, a provision that legally permits slavery to continue for anyone convicted of a crime. I want to be fair to the historical context, because this story requires fairness to be credible. The men who drafted and ratified the 13th Amendment were, by the standards of 1865, doing something extraordinary. The amendment wiped out the most brutal system of chattel slavery in the Western Hemisphere. The exception clause was not written with malice by men cackling in a back room. It drew on language from the Northwest Ordinance of 1787. That same exception clause appeared in the Territorial Governance document 80 years earlier and had been carried forward without substantial debate. It was a provision that most of the amendment's drafters likely understood as a minor qualifier, covering cases of actual criminal conduct, not as a mechanism for wholesale re-enslavement. Senator Charles Sumner of Massachusetts objected to the clause during the amendment's drafting. He argued that the exception was dangerous, that it created a loophole that would be exploited. He was, of the men in that room, the one who understood most clearly what Southern legislators would do with it. He was outvoted. The clause stayed. What the drafters failed to account for, or chose not to examine, and Sumner's objection suggests at least some of them knew, was what happens when a state can define crime broadly, selectively enforce that definition against a specific population, and then claim the constitutional right to extract forced labor from the resulting convictions. The exception clause is a door. Samuel James walked through it. The Louisiana legislature walked through it. Every state that enacted black codes and convict leasing walked through it. And the door is still open. The numbers are not ambiguous. Louisiana's prison population is approximately 70% black, in a state where black people make up 33% of the general population. The United States incarcerates people at a higher rate than any other country on earth. The Federal Bureau of Justice Statistics estimated that in 2022, incarcerated people in the United States performed labor generating somewhere between $11 billion and $14 billion annually. The compensation for that labor, where compensation exists at all, ranges from nothing to a few dollars per hour in the most generous state programs. 22 states, as of this filming, still allow forced prison labor without pay. Not reduced pay. No pay. Oregon's constitution still contained language permitting slavery as criminal punishment until voters approved an amendment in November 2022 to remove it. Alabama, Tennessee, and Arkansas voters passed similar amendments in 2022. The 13th Amendment's exception clause itself has never been modified. It sits in Article 1 of the Bill of Rights like a footnote to freedom, and it is the footnote that Angola has been living in for 150 years. There are advocates and legal scholars who have been working to close the door. At the federal level, the Abolition Amendment, A proposal to remove the exception clause entirely from the 13th Amendment has been introduced in Congress in various forms. The argument for it is straightforward. If the stated purpose of the 13th Amendment was the abolition of slavery, then an amendment to that amendment which retains a provision permitting slavery is internally incoherent and should be corrected. The argument against is more procedural than principled. The amendment process is slow and politically costly, and the resources required to move a constitutional amendment through 2/3 of both chambers and 3/4 of state legislatures are not currently aligned in favor of this change. That calculation, the political cost of ending something, is worth sitting with. The political cost of ending something that everyone agrees, when asked directly, is morally wrong. There are very few people who will say plainly on a camera that they support slavery. There are many, many people, legislators, corrections officials, prosecutors, voters, who support the specific legal mechanisms that produce outcomes indistinguishable from it. The gap between those two positions is where Angola lives. There are advocates and legal scholars who have been working to close the door. Oregon voters passed a measure in 2022 to remove the exception clause from their state constitution. They were among the first to do so. Several other states have introduced similar legislation. As of this filming, the federal exception clause remains. The argument against removing the clause, the argument made by corrections officials, by some legislators, by people who speak carefully about rehabilitation and structure, is that work programs in prison serve a function, that they give inmates purpose and skill. That forced labor is not the same as what Samuel James operated. The wages are real, even at 4 cents per hour. The conditions are better. The law provides oversight. I'm going to give you those arguments as honestly as I can, because they are what the people who defend the current system actually say, and a story that doesn't engage with the best version of the opposing view is not doing its job. Some Angola inmates speaking to journalists over the years have said they prefer working to sitting in a cell. That is a real thing real people have said, and I am not going to erase it. What I am also going to say is this: 4 cents per hour is not a wage. It is the performance of a wage. A man who earns 4 cents an hour working an 8-hour shift earns 32 cents. A candy bar from a prison commissary costs approximately $1. The wage does not sustain life. It does not accumulate into anything. It cannot be saved, invested, sent home, used to hire an attorney. It is the smallest possible legal acknowledgement that the labor has economic value, an acknowledgement calibrated, it would seem, to give just enough cover to the system that holds it. And the system that holds it is the same system that decided, in 1901, to build a prison on that particular land and name it that particular name and put those particular men in those particular fields and run those rows in that particular direction. His name is Marcus Williams. He is a composite, built from the documented experiences of multiple Angola inmates whose cases have been covered by journalists, advocates, and legal organizations, including reporting by the Marshall Project, The Advocate, and the New York Times. His details are assembled from real records. He is not one man, but he is true. Marcus Williams grew up in New Orleans, in the 9th Ward, in a neighborhood that took 8 feet of water during Katrina when he was 7 years old. He grew up in the aftermath of that, in FEMA trailers and temporary housing, and the particular disruption of a childhood rebuilt twice in the same decade. Once from the flood, and once from the poverty that followed the flood. His mother worked. His father was not present. He attended John F. Kennedy High School, which was among the schools that were closed and reopened and reorganized in the post-Katrina years, its enrollment shifting and its teachers turning over faster than anyone could form relationships. Marcus was not a bad student. He was an inconsistent one, which is different, and the difference matters. He was 22 when he was arrested. The charge was second-degree murder, a conviction that came out of a night in 2019 that involved a fight, a weapon that belonged to someone else, and a legal theory called felony murder, which holds that a person can be convicted of murder for a death that occurred during the commission of another felony, even if they did not pull the trigger or intend the death. Felony murder statutes vary by state, but are on the books in most of them, and they are disproportionately applied to young black men in situations where multiple people were present, and prosecutors have discretion about whom to charge and at what level. Marcus was tried. His court-appointed attorney had 43 open cases at the time of trial. The trial lasted 2 days. He was convicted, sentenced to life without parole. He arrived at Angola in the fall of 2020. He was processed, intake, medical screening, classification, assignment, with the institutional efficiency of a system that has processed thousands of men through the same gates. He was given his white uniform. He was assigned to a dormitory in one of the agricultural work camps. A guard showed him his bunk. The mattress was thin and smelled of previous occupants. The man in the next bunk was 47 years old and had been at Angola for 19 years and did not look up when Marcus sat down. He was assigned to field duty the following morning. His first morning in the fields, the sun was not yet fully up. The sky was that particular pre-dawn gray that sits just before the pink comes in. The sky of a world that hasn't decided yet. He could feel the mud through his boots, soft and giving. The kind of ground that makes a sucking sound when you pull your foot up. The air smelled like the river and cut grass and diesel from the tractor idling somewhere behind the tree line. He was 22 years old. The other men around him had been doing this for years, decades, some of them. There is a kind of silence that develops in people who have been doing the same work in the same place for a long time. Not resignation exactly, but a compression of self, the way a tree grows around a fence wire until you can't tell where the tree ends and the wire goes through it. Marcus could feel it in the men near him, the way they moved without waste, the way they didn't look up. He looked up. He looked at the rows running north to south across the flat land, all the way to the tree line, and then past the tree line to the river bend that holds this land on 3 sides like a hand. And he thought something. We don't know what he thought, because he is a composite, and composites don't have interiority we can verify, only the interiority we can reasonably infer from what people in his situation have reported thinking. What men in his situation have reported thinking, in interviews and memoirs and legal testimony and letters smuggled out and read at advocacy events, is something like, how long? How long is this? How many times will I walk this row? His sentence is life without parole. The answer to how long is all of it. The guard on horseback was 100 yards to his left at the edge of the field. The horse moved slowly, head down, switching its tail at the mosquitoes that rise off the wet ground every morning. The guard did not speak. The sun was coming up over the tree line now, orange and flat, hitting the white uniforms and making them glow for a moment, before the glare settled into ordinary morning. The tractor groaned into gear somewhere behind him. The men around Marcus moved into the rows. He moved with them. The ground under his boots is the same ground that was plowed in 1855. The soil that sticks to his soles is the same soil, the same black clay deposited by the same river over thousands of years of flooding and retreat. There is no metaphor here to reach for. It is the same land, the same rows, the same direction. Isaac Franklin bought this land with money made selling people. Samuel James leased men to work it after the war. The state of Louisiana bought it in 1901 and named the prison after the country those people came from. The 13th Amendment said, except as punishment for crime. Louisiana's courts produced the convictions. Angola produced the labor. For 150 years, every piece of this machinery has worked exactly as designed. I've been building toward one question since the beginning of this video, and I want to ask it plainly now, with nothing around it. Is Angola still a plantation? Not a prison that resembles a plantation. Not a prison with plantation characteristics. Is it, in the technical sense, in the land use sense, in the labor structure sense, in the legal sense, a plantation? The land, 18,000 acres. Predominantly agricultural. Worked by a predominantly black labor force. The labor structure, compelled. Wages set by the institution, not by negotiation. Refusal to work punishable by solitary confinement. The legal framework, 13th Amendment, Section 1. Except as punishment for crime. The name, Angola. The crop rows running north to south. I have tried, in the course of making this video, to find the sentence that makes this not true. The sentence that explains why the direct line from Samuel James to Burl Cain to the present day is not what it looks like. I looked for it in the records of the Louisiana Department of Corrections. I looked for it in the reform literature. I looked for it in the arguments of the people who have managed Angola and defended its programs and pointed legitimately to the hospice and the reduced violence numbers. I could not find the sentence. What I found instead is this: the crops have changed. The buildings have changed. The pay, 4 cents to 40 cents, is real, legally speaking, and was not present under slavery. There is a distinction between the 19th century and the 21st century that a serious accounting has to acknowledge. The men at Angola today are not the same as the men on the Partridge Plantation in 1855. The legal frameworks are different, the stated purposes are different, and the rows run the same direction, and the men are predominantly black, and the sentence is life, and 75% of them will die there. Wilbert Rideau, after his release in 2005, wrote a memoir called In My Father's House. He has given interviews, written essays, lived in the free world for nearly 20 years now. He has not made peace with what Angola is. He has made peace, carefully and partially, with what he survived. Those are different things, and he is precise about the difference. In one interview, he was asked whether he thought Angola could be reformed. Not abolished. Reformed. Made into something that served a legitimate purpose in a way that wasn't built on the architecture of forced labor. He paused for a long time before he answered. Then he said, Angola is what Louisiana wants it to be. And until Louisiana wants something different, it's going to stay what it is. Norris Henderson is still in New Orleans. Vote is still operating. He is still testifying, still organizing, still doing the work that innocent men who are released sometimes do when they have decided that rage alone isn't architecture. The George Polk Award that Wilbert Rideau won in 1994 sits somewhere. I don't know where exactly. In a box, maybe, or on a shelf in his New Orleans home. He earned it in a cell with a typewriter and a legal pad, and the specific kind of clarity that comes from having 30 years to think about what you are doing and why. The award is real. The cell was real. Both things exist. The system produced both. The 13th Amendment has not been amended. The exception clause is in the document. You can read it right now. It is publicly available. It is not disputed. It is the text of the law of the land. Except as punishment for crime. 5 words, 1 door. 150 years of men walking through it against their will. Marcus Williams is in the field. He is 22 years old, and the rows run north to south. And the sun is fully up now, and his boots are dark with black Louisiana clay. and somewhere behind him the tractor turns at the end of a row and starts back. The same direction. The same soil. The same name on the gate. He walks the row.